Chesapeake Region Safety Council welcomes you to today's webinar, Legal Cannabis and Workplace Safety, presented by Adele Abrams. This webinar is being recorded. The video and presentation will be available to view later on our website under the Resources tab, Safety Webinars. You can find a variety of safety and health topics on that page as well, including impaired driving and workplace safety. The Q&A feature will be open throughout the webinar. Please feel free to type in any questions you may have. If your question's not addressed during the presentation, we'll be sure to reach out to you later. Here is our phone number and email address. Jot those down or pull out your phone and take a pic of the screen. Save it so you can contact us later. Our staff looks forward to hearing from you. I'm Kim Beard, Education and Training Coordinator, and I'm joined today by a few of my coworkers at the Chesapeake Region Safety Council. Dave Medeiros, our President, Rod Markley, our Vice President, and Debbie Jennings, Director of Highway Safety and Special Projects. Good morning, Debbie.
Good morning, everyone. Thank you, Kim. Chesapeake Region Safety Council has been conducting cannabis use and impairment training courses for 4 years now. One of the components is a cannabis use workshop that's conducted at the end of the impairment education course. We will be holding more of them later this year. The next one open for registration will be in October, and the link is going to be in the chat on our website. We hope you join us. They're very successful.
Thanks, Debbie. And okay, guys, it's time for a quick poll. Let's see here. You should see a poll pop up on your screen. Is this your first Chesapeake Region Safety Council webinar? All right, you can answer that. We got a lot of yeses coming in and a few no's. Dave, it looks like we have a good mix of veterans and rookies here.
That's awesome. All right. Well, hey, good morning, everybody. My name is Dave Medeiros. I'm the president of the Chesapeake Region Safety Council. We are a regional independent chapter of the National Safety Council, and our mission is to educate and influence people to prevent accidental injury and death. If you want to summarize what we do, is saving lives and preventing injuries is what we're all about. That's what we're up to, and that's what we're trying to accomplish. And this is a great opportunity to learn a little bit more about cannabis. And we have, probably one of the, I want to say, I sometimes I scare myself whenever I say this about people, but I would say Adele is an expert at understanding cannabis laws and different innuendos about it throughout the country. So I want to introduce Adele Abrams. Adele is our recent past CEO of the Chesapeake Region Safety Council. She's a workplace safety professional. She is also an attorney, and good grief, I know that Adele knows a ton about this stuff, and each and every one of us that is participating in this webinar today is going to come away with a bunch of information that you did not know before you started. So without further ado, I want to turn the floor over to Adele Abrams, and have at it, Adele. Thank you.
Okay, can you see my screen there? And
yes, sure
we're going to go back to the very beginning here, so you get the full enchilada. And good morning, everybody. I appreciate the fact that there's 65% of you who haven't been on one of these webinars before with Chesapeake Regional Safety Council. So welcome, and remember that they do have an awful lot of offerings, including free programs like this, and anybody in your company is eligible to sit in on these. So make good use of your membership benefits. There's my plug, as the past CEO means that I'm in the rearview mirror there, but it was my privilege to serve in that capacity. So we've had a lot of changes in cannabis law in recent years, and even in recent months, dare I say it, this month. And so we're going to talk kind of at a 15,000 foot level about what's going on with the laws. And then we're going to hone in on the Maryland law specifically. And bonus points here, you're also going to get an update on Pennsylvania and on Virginia. because there's some important things going on there as well. So we're going to at least cover that tri-state region. Of course, Washington, D.C., the city District of Columbia, has had legal cannabis for years, but because of that quirk of them being somewhat controlled by Congress and not having their full states' rights, so to speak, they've never really been able to set up any recreational dispensaries in DC. They do have medical dispensaries. And so we're in an ironic situation now where people in DC who want recreational weed may be going to Maryland to buy it, because the Maryland dispensaries are now in full bloom, and Virginia is still lagging a little bit behind. So that, of course, obviates the fact that you're not supposed to carry it across state lines. And so I'm not saying we're going to see checkpoints at the Maryland DC borders or Maryland, Pennsylvania or Virginia borders, but do be aware of that for those of you who might decide you want to try the wares a little bit, that legally you cannot transport it between Virginia and Maryland and DC and Delaware, even though it's legal now in all of those jurisdictions. So that's just one example of kind of the practical quandaries that may be arising here in the future. And that would include, of course, if you're driving, I'll do this one for Debbie, and you have a passenger in your car who is transporting cannabis across state lines. The legal liability you have as a driver may well depend on whether you know what's in the contents of their purse or their briefcase or their pockets. So just tuck that one away for future reference, because that's going to be case law to develop in the future. So let's start off, though. This is, of course, being deemed a safety webinar, which it is, but it is also a bit of an HR webinar, because this is one area where you really do have the intersection of safety and HR law. And with OSHA added into the mix, of course, they come at it from two directions. They look at it that employers have the obligation under the General Duty Clause, Section 5A1 of the Federal Occupational Safety and Health Act. So that's in effect in DC and Pennsylvania and Delaware. Maryland and Virginia, which run their own OSHA programs, they have analogous provisions in their state statute. But that general duty says that employers must protect workers from recognized threats that could cause death or severe harm to employees, and that includes to the employee themselves. And there has to be a feasible method of abating that. Well, drug testing programs, prohibition on drugs in the workplace, those have historically been one way that you do it. And this is a power that OSHA has that they haven't used historically a lot. They have used it some, though. And typically, if an employee, say, is killed, and it comes back as a positive test for drugs or alcohol, if a supervisor says, oh, I smelled something on them, but I didn't say anything because whatever, then that knowledge is imputed to the employer. And that is one way that recognition of impairment or potential drug use would be used by OSHA. Maximum penalty now is $156,000 per affected worker. So in the scenario where somebody has been drinking, or in this case using cannabis recently, you smell it on them, you tell OSHA that, and maybe they're operating a forklift and they run amok in a warehouse and they run over 3 people. In that case, now under their instance by instance policy, OSHA could do 156,000 times 3. So this has some real consequences for business from an economic perspective, as well as, of course, the human toll that people who are impaired in the workplace can take. Now, is everybody who smoked cannabis going to be running amok with a forklift? No, not even a little bit. And we're going to talk about impairment here a little bit down the road. And that is part of what these green labs that Chesapeake Region Safety Council is doing, is to help really hone in on what distinguishes cannabis impairment from, say, alcohol impairment. Somebody on cannabis who's used it actively, they can usually pass a field sobriety test for alcohol with flying colors. That means that a lot of what you've taught your people to recognize in terms of reasonable suspicion of impairment may not hold true. Even some of the things I've mentioned a couple of times, I smelled it on them. But what about if they're using edibles? edibles are a very popular way of using cannabis. Leaves no smell. You typically aren't going to have the red eyes that are another indicia of it. You're not going to have the munchies typically with the edibles. Now, vape pens, that's another methodology of delivering the drug or the medicine, depending on your perspective. Again, does not leave a smell on the person, doesn't leave a breath odor. And so what an employer is looking for in terms of signs of cannabis use have really changed. There's pills now, just like a capsule you take with, omega-3 in it, and they sell those with, the equivalent of a couple of good size edibles in it for people for medical use. But those are going to be available for recreational purchase as well. And so, somebody might just have it in a private pill case that an employer typically would not see or have access. It's not as simple as leaving a bag of gummies in your desk to give somebody a heads up on use on the job. So all of this is going to be very much a brave new world. But under OSHA, under the general duty clause, do you have an obligation to have a workplace free from people who are impaired? Yes, you do. Now, on the flip side of that, though, OSHA has also taken the position that drug testing somebody solely because they were injured as a knee-jerk reaction, that could give rise also to citations under 29 CFR 1904.36, which is part of the electronic record keeping rule. And it says you can't retaliate against individuals for reporting injuries and illnesses. And it further incorporated by reference Section 11C of the Occupational Safety and Health Act. Again, a little bit of legal mumbo jumbo here, but the distinction is the statutory provision 11C. The recourse for that is OSHA does an investigation if you file a complaint within 30 days that you've been discriminated against. Very short statute of limitations there. But if OSHA finds there's merit, they can take that case to the U.S. District Court. And there've been cases, of late where they've gotten over $1 million in punitive and compensatory damages. So again, no small potatoes there. But what about under 1904.36? Well, that's the fallback position, Plan B, we might call it, for the person who is perhaps terminated as a result of a positive drug test, even though it's not really consistent with active impairment. And OSHA, in that case, gives them 180 days to file a complaint with the agency that they've been discriminated against. And OSHA can investigate that and issue a citation to the employer with a penalty, again, up to 156 grand. Okay, that's great. OSHA gets some money, or more precisely, the US Treasury does, at least in the case of federal OSHA. But what about the worker who got terminated? The abatement for the citation under 29 CFR 1904.36 would be reinstatement of the worker with back pay, restoration of benefits, seniority, etc., purging a record of discipline, whatever relief the judge orders or is agreed upon in a settlement. And so OSHA's parameters on when you can drug test post-accident, not surprisingly, have shifted between the Obama administration and the Trump administration, and now we're in the Biden administration. So I'm going to give you the skinny on that as well. But that's another thing that, complicates the mix here. You're not just dealing with perhaps a wrongful termination claim that could be brought under a state or federal statute, and more about that in a second, but also potentially OSHA could get into the mix. I think that the technical term for this is damned if you do and damned if you don't. If you don't drug test and people are allowed to be impaired on the job, you have liability under the general duty clause. And if you have a knee-jerk reaction, where OSHA's view, why does OSHA even care about drug testing? It's because they view that as having a chilling effect on people reporting an injury. And if I cut my hand, and maybe I could take stitches. I just took the first aid course last week at Chesapeake Region Safety Council, and I highly recommend it. But sometimes it's difficult to tell whether compression on something will stop the bleeding or whether you need to go to urgent care and get stitched up. If an employee knows that they're going to be drug tested if they ask to be taken to urgent care, they may try to hide the injury, under a work glove or something and a bunch of bandages, and then get it stitched up off the job. That deprives the employer of knowing that an injury occurred and that there could be an extant hazard, like a ragged guard or something, upon which the person cut their hand. So the employer should have a vested interest in incidents being reported timely. And if people are dissuaded from doing that because of fear of drug testing and termination, you're going to lose data. And from OSHA's perspective, the data that is electronically submitted to them is skewed as well. Hence the connection with the electronic record keeping rules. So now you know how that all fits together. I'm sure you've been wondering for years. What about MSHA, my favorite agency? It's the Mine Safety and Health Administration. And we do have stone quarries and sand and gravel operations and cement operations, as well as coal mines and some other surface and underground stone mines in our region. Well, MSHA actually does have a regulation that prohibits the employer from allowing anybody to be under the influence or in possession of alcohol or narcotics. That's how they phrase it, at metal and non-metal mines. That includes contractors. And I had a case not long ago at one of these mines where MSHA asked a contractor to open their toolbox. They opened the toolbox and they had a bag of weed in there. And they got cited, but the host employer, the mine operator, also got cited as a result of the contractor's violation. And MSHA maximum penalties now are $313,000, twice what OSHA's are. And they can also personally fine supervisors who engage or have knowledge of the violation or engage in it. They can be personally fined up to $85,000, which is a power that OSHA doesn't have. So for those of you who are in the construction industry, maybe on the call here, and you get a call to put a new roof on a scale house at a quarry, just be aware you're under different jurisdiction. And if you have a 6-pack in the back of your car or your work truck that you're planning to drink after work, you can be cited for that by MSHA. And they have warrantless search authority. So they do search people's cars. Again, I had a contractor recently, and the mine operator got cited for this. The guy was impaired on the job. They called MSHA to report it instead of just having the guy go home. MSHA came, asked the guy if he was drunk. He said yes. They said, "Did you have any alcohol on you?" He said, "It's in my car." They said, "Can I check?" He opened the glove box and there was a bottle of bourbon in there. And again, citations all around. So don't mess with MSHA. That's really the bottom line here. So back to the view of cannabis, lots of changes. Just in the past month, we've had dozens of varying laws taking effect. And in some cases, these aren't new laws, it's tweaking of existing laws. And this is something where you really need to keep a scorecard if you're a multi-state employer, because, for example, you may have bare bones medical cannabis laws that simply say you won't get arrested and you can legally buy it, but they offer no employment protections. And then sometimes as these recreational laws get passed, and Virginia is an example of that I'll give you in more detail in a moment or two, they go back in and they revisit the medical cannabis laws and add worker protections. And sometimes we're all, looking at the shiny object, the new recreational law, and we miss the changes that are made to the existing medical laws. So Maryland, front and center here, obviously, recreational cannabis possession, personal cultivation, suddenly everyone's a gardener, right? And also retail sales are now legal. I live in Delaware. We have legal recreational cannabis as well. That just occurred this year also. It's not even on this list, but it's earlier in 2023 below. However, we do not have recreational sales, and they're really at the baby steps of figuring out, whether they're going to let the medical dispensaries also sell recreational. It's probably a good year off here for Delmarva, where I am in Delaware, but Ocean City, Maryland, their recreational dispensary is alive and thriving. So are people from, Fenwick Island and Bethany Beach going to hop the line? I think that's probably likely. Are they going to have roadblocks checking people? Beats the heck out of me. But if you go to the beach on vacation for the rest of the summer, stay frosty is what I would say. Connecticut, they have had legal recreational and medical cannabis for a while. The new thing they added was being allowed to grow it at home. For people on a limited budget, that's obviously a big boon. Virginia and Nevada some of the changes that they made to their medical cannabis program previously just took effect, typically as of July 1st, all of these changes are. New Hampshire, they are now offering reciprocity with out-of-state medical patients in their medical dispensaries. There's about a half a dozen now of these medical states that are offering reciprocity. Some of them offer it to Maryland people, some of them don't. Some of them offer it to Delaware patients, some of them don't. It's very crazy quilt. Hawaii, notably, I found this out when I was up there speaking at a conference last October. They decided, let's make some money on the tourists. And so if you have a medical card from any state, you can apply online, pay Hawaii. I think it was, I don't know, I mean, I didn't do it, but I think they said it was $50 or something. And you get a card that you can use in the Hawaiian dispensaries for 60 days. So it doesn't give you a permanent card, just long enough if you're staying for a vacation. And then you come back, a few months later, you got to buy another card. So, maybe Maryland or some of the other states will hit on that approach. But I have wondered as an attorney for a while why that reciprocity wasn't there, and indeed even the travel across state lines under the full faith and credit laws. And it is kind of crazy that somebody who has a prescription for Vicodin in Maryland can go to Delaware to the beach with that vial in their suitcase, and it is not illegal. But if they have medical cannabis from a Maryland dispensary and they travel to Delaware to go to the beach where it is now legal, it's still illegal to bring your medication across the line with you. So someone somewhere is going to litigate the full faith and credit laws on that one. I don't know if it'll be me, but it would be a fun case. Some more changes. California and Louisiana, they went back and did huge expungements of prior cannabis offenses. Maryland, you'll see in a moment, has that built into their law. Virginia as well. And at the federal level, of course, President Biden included that in his announcement, urging DEA to legalize recreational, or just rather, I shouldn't say recreational, to decriminalize and delist cannabis from the controlled dangerous substances list. But he did order expungement of all of the federal cannabis possession nonviolent offenses. And I know at the time, some people were going, well, that's a whole lot of nothing, but it really isn't. If you think about it, if you go to Wolf Trap, that's the National Park Service. If you're caught with cannabis there, that is a federal charge. There are certain roadways that are federally controlled and would bring a federal charge. I think the BW Parkway might even be one of them, but someone may correct me on that. Military bases, national parks. So there are an awful lot of people who did have simple possession cannabis charges at the federal level. So they will get relief now. And in Maine, this is another where they've now eliminated the ability to drug test people who are on probation because, of course, cannabis is a legal drug. Earlier in the year, Delaware went to recreational. Minnesota, they did a real kind of quarterback sneak on that one. And finally, Kentucky legalized medical cannabis. So, I said when Utah fell and legalized medical cannabis that, the writing was on the wall there. And so, what's up next? They're looking at medical cannabis for North Carolina and Ohio. So stay tuned. And I know some of you have regional companies, that do operate in those states. This is another thing, and we'll talk about this as we get toward the end, but how are you going to reconcile having this crazy quilt of an HR policy where people in some states who work for you may be allowed to use it off the job, and yet you don't have those same provisions for people in other states? What does it mean when you have people working, say, in Virginia, which has protections for workers, but your company is based in Maryland? What if they live in Virginia, but report to work in Maryland? And vice versa. So these are all of the things that an employer really has to think about now in terms of harmonizing their program to have something that is cohesive, that will pass legal muster. So moving right along here, where are we now on the scorecard? 41 states plus DC and all of the territories have legal medical cannabis. And the latest ones, that fell again, we just talked about Kentucky, but also Alabama and Mississippi. So we're getting into the deep red territory now. And once medical cannabis is legalized, as we can see, the recreational efforts now are coming, fairly quickly on their heels. 22 states now, plus DC and a couple of territories, have legalized recreational marijuana. And at the same time as we've seen this groundswell approving the laws, Arkansas, North Dakota, and South Dakota rejected initiatives for that. Now, those will be back. Nebraska also just missed what they needed in terms of their petition deadline, and they're taking another run at it. NORML, the National Organization for the Reform of Marijuana Laws, I'm not putting this out there as in, support the organization, but they do have a really awesome website that gives you links to state by state by state, and they update it regularly. I have other sources that I track, the state governments, the National Association of Governors, there's state legislatures, there's a number of websites you should all keep an eye on if you are tracking this for your company and you're not hiring somebody to do it for you. But you do have to really stay on top of this, because it's not just the state laws, but also municipal and county laws that offer greater protections for cannabis users than even at the state level. And if you miss a beat on that, you can be in a world of trouble. So, if you're doing work out in San Francisco or New York City or Philadelphia, Las Vegas, there's going to be municipal laws that are definitely going to enhance the protections for users. Another example of just weird little law changes. I just saw this yesterday, so I had to include it in. The Michigan Civil Service Commission voted unanimously to adopt new rules ending pre-employment marijuana screening for most state workers. The exclusion is law enforcement, and anybody who failed a test when they applied for a job with the state in the past can now reapply. There's not going to be a ban on their eligibility. I think we're going to see these kind of things cropping up. So for those of you who work for municipal or state governments, and I know, sometimes we do have people from the public sector who participate in these, don't think, hey, these private sector guys are getting all the fun. What about us? It is changing there as well. I mentioned already, President Biden has called for declassification and issued the pardons. And I think the bill to watch is the Veterans Equal Access Act. This was reintroduced this spring. It already has 21 bipartisan co-sponsors. Now, we're running out of time, before the end of this legislative year, but it would carry over. And this legislation would allow veterans to get access to cannabis or to get cannabis cards through the VA. That's going to be a real game changer, because, we do want to, of course, encourage hiring of veterans, and veterans are ubiquitous, throughout many of our industries. Once they start using it legally through the VA, especially if they're using it for PTSD, for stress, for chronic pain arising from their service, it's awfully hard for employers to say, well, sorry, we're just not going to consider you eligible to work here anymore. So that's another thing you need to keep an eye on. Is it going to be passed this year? Probably not. Could it get rolled into some kind of omnibus bill at the end of the year? Yeah, that's possible, especially because it is bipartisan. The one thing that Congress seems to agree on is cannabis. I like to say the Democrats like to smoke it and the Republicans like to sell it. And that's kind of true, but, be interesting now that it's legal in Kentucky to see whether Mitch McConnell gets himself a card or not. So maybe he'll speak out on it down the road. The other, though, big thing about federal legalization, and this is really the crux of it, is that once that occurs, all of the federal ADA case law upon which employers have relied to say, hey, we don't have to accommodate this, that all goes away, because the only reason that the medical cannabis patients have lost at the federal level is because of the illegality of cannabis federally. Its classification as a controlled dangerous substance. At the state level, and I'll give you a couple of examples of these just in a moment here, you'll see it's win after win after win. They invoke the state version of the ADA, they couple it with a bare bones medical cannabis law, and voila, the courts say, yes, you've proven your disability, you're eligible for this card, we are not going to let employers dictate what treatment you have and maybe force you back on opiates if you're using this as an alternative to opiates. And so, we wouldn't have time anywhere close to the time we have allotted here to go through the litany of all of the states now that are ruling that way. Now, what about Maryland, though? Because, of course, Chesapeake is based in Maryland, and that's the latest state. Well, Maryland is one state where we don't have a precedential level decision opining on that. But we're being surrounded by it. So I think it's just a matter of time. I mentioned OSHA having a policy on drug testing post-accident. And when the Obama administration issued the electronic record keeping rule in 2016, seems like a lifetime ago, doesn't it? And the new rule just came out, by the way. So the reporting criteria have changed. That's a subject for another webinar, but keep an eye on that because it's going to affect this year's data. Back to the drug testing. The Obama administration said you could not drug test someone because they were injured, solely because they were injured, unless the employer had a reasonable suspicion that the person was impaired and that the impairment was causally connected to the accident. Whoa. So you'd have to do an awful lot before drug testing that person, at which time, it might or might not still capture the results. Well, the Trump administration changed that, issuing clarifying policy in 2018. And I was waiting to see what's the Biden administration going to do on this. Frankly, I expected that they were going to go back to the Obama version, but they surprised me. They did not. And last year, 2022, OSHA reissued and updated its whistleblower handbook. And in that, they incorporated by reference the Trump policy. So where things stand now, OSHA doesn't care anything about random testing. They don't care about any testing unrelated to the reporting of an injury or illness. They said if you drug test under a state workers' comp law or contractually, that's fine. If you have to drug test because of DOT, that's fine. And so if none of those exceptions apply, though, and it's an injured worker who's being tested, what OSHA says now is you can do it as long as it's part of a root cause investigation. And if you're going to drug test the victim, the person who was injured, you also have to drug test anybody else whose conduct could have contributed to the incident. So to use an example here, Kim is operating a forklift. I'm walking in a warehouse in a pedestrian-only lane, minding my own business, and without warning, she rams me from behind and breaks my leg. Now, I don't care if I smoked a joint that morning. My impairment, if it's present, was not a causal factor in that accident. But, Kim, you might be looking at her. Why did she ram me with the forklift? Now, under this policy, you could drug test me even though you did not suspect impairment, but you would also have to drug test Kim. And then maybe Kim says, well, hey, Dave Medeiros, the mechanic, he told me he fixed the brakes on that forklift, but when I went to stop, they didn't work. Now maybe Dave is getting drug tested as well. Sorry, Dave. So the point is, you actually have to do a root cause investigation and follow the chain in terms of drug and alcohol testing, as far as OSHA is concerned. And then, of course, do an actual root cause investigation. So we have another poll up here now for folks to take, and be interested to see the results of this. So the bottom line is OSHA has taken a step back from you having to suspect impairment in order to test an accident victim, but you can't stop there. You do have to test anybody else whose conduct could have contributed to it. So if boxes fall off a shelf and they hit the person and injure them, again, not their fault, but who stacked those boxes? You're going to have to figure that out. So a lot going on there, and I'll continue on while the poll is going on. So here we are in Maryland now. Recreational cannabis took effect as of July 1st, which is now in our rearview mirror. And adults 21 and older, so this does not allow your kids to go into a dispensary and buy it. Don't worry about that. Yes, they do card. I think they're probably a little bit more diligent about this actually than, say, the bars down here on the Eastern Shore where I live. But they should be carding too. And there's a total amount you can buy. That's personal use amount. I'm sure you all aren't that interested in that. Now, earlier this year in March, the Maryland House voted for a measure to create a framework for this, but that all ended up happening, and now it is for sale, in the medical dispensaries. I think there may be some that are still medicinal only. What you do, for those who are looking for this, you can go on the website and it will ask you, are you 21 and over? And then some of them, and this is how other states run it as well, they will have a page for recreational, they'll have a separate page for medical. I haven't been in a Maryland dispensary, so I can't speak from personal experience on this, but I know in some states there are stronger products that are reserved for medical use, including in edibles, and there are weaker products for recreational use. I'm not really sure how Maryland is planning to handle that, but if anybody out there reports back at the end of when we get into the question period, I guess we'll know. And the ballot that was passed, this was something that the voters directed, not the legislature. It includes that expungement where there was possession, of very small amounts. And here we're talking about typically less than about a third of an ounce. And with it being possession only, not distribution, no weapons charges, no, negligent homicide, driving offense or anything like that. Also, the amount was subject to a civil fine, and that went up to 2.5 ounces. Now that took effect January 1st, but that again was in anticipation of the legal sales. There are limits on how much you can buy as well in dispensaries. So that's another thing. You can't go in there and say, hey, give me a half a pound of weed and then go home and sell it to your neighborhood. You're not allowed to resell it. There are a lot of restrictions on the purchase and the purchaser. So be aware of that. It remains illegal to transport it across state lines. I mentioned that earlier. And it's also illegal on federal land and federal buildings. If you work at NIH, don't bring it with you onto the campus there. It's going to be illegal. National parks. And that's, of course, also in other states, even where it is legal. So beyond that, let's see, is our poll closed before I move on here? Yes, it is closed. So I will share the results and see if you all can see those. Hopefully you can. It looks like the majority of folks who responded are doing testing under all types of conditions. Some are doing just pre-hire, 13%. Reasonable suspicion only would be the second highest category at 20%. And then no testing, 18%. Post-accident only 13 for those who might be listening simply audibly. So moving right along here, what else in Maryland? Well, it doesn't specifically address employee use of recreational cannabis. And there's currently no protections for medical cannabis users in terms of workplace rights. So employers in Maryland are free to, prohibit on-the-job use, certainly, prohibit, coming to work while impaired or intoxicated by alcohol or drugs, and testing can still be done. Maryland does have certain prerequisites on how you do your testing. You have to do the split sample. I know when they first came out with those oral swabs, for example, that were just one use and done, those did not meet the Maryland testing requirements. They have split sample approaches now because the person being tested has to have the capability of having the test redone, at their own expense typically. And again, look at union contracts and all, because those could differ. And so another thing that's interesting in Maryland is that they specifically have brought cannabis and hemp products. There are CBD cigarettes that are sold now in smoke shops that are not tobacco at all, but those are included now under Maryland's ban on indoor smoking. And I actually had this Mosh case on a construction site where there were a few walls up but no roof. and not all four walls. And I got most to agree that that was not considered indoor smoking. So you can take that for what it's worth, but that was cigarette smoking. That was not cannabis smoking. And also employees who might complain about other workers smoking or participate in proceedings under Maryland's Clean Air Act, they are protected from retaliation by the employer. So remember that as well. You can't drive and smoke cannabis. That's pretty ubiquitous around the country. You're not allowed to smoke in a vehicle on a public roadway. Can you sit in your driveway off the roadway in your car and smoke some weed before going inside if you don't want to smoke in the house in front of the kiddos? You can. I did actually handle a case where a medical cannabis patient in Maryland and Prince George's County was in her car just smoking cigarettes with friends, and the police knocked on the window, and this happened to be a bit of racial profiling, to be blunt, and said, well, I know somebody in this car has marijuana. And she said, yes, I have it. I'm a medical patient. He wouldn't let her take her card out. He took her marijuana and poured it all into one bag out of the medical containers, and then booked her for having the marijuana. And we did get the charges dropped in that case. And apparently there was a bit of that going on in that area of Prince George's County. But that hopefully is an outlier. So if you're on your private property, she wasn't smoking it, but even just being in possession of it, she got hassled. On your driveway, though, in your backyard, in your garage, you can be in a vehicle. It's driving, it's being on a public roadway. And if you drive as part of your responsibilities on the job, that's something there where, they could get in trouble if they have it in their purse or their pocket while they're on duty in a company vehicle. You don't have to be smoking it. It's simply, possessing it is allowed. Excuse me. I want to go back on that, but be careful about having it. And when we get to Virginia, you'll see there is a nuance there. I was confusing it in my head for a moment. You'll see this stuff does get confusing. So yes, you can buy it. You can legally transport it in your car, but you can't smoke it in your car in Maryland. I'm expecting there to be more legislation introduced addressing off-duty use of recreational cannabis, and also what they might do in terms of employment, but we're not seeing that in this legislative session. So Pennsylvania, there's a little bit of action going on right now. I wanted you to be aware of, because parts of Pennsylvania are within the Chesapeake Region Safety Council's region. Senate Bill 846 in Pennsylvania would legalize adult use of cannabis and allow you to have up to essentially an ounce. An ounce is 28 grams. This allows 30 to allow for a little measurement error, I suppose. It would also allow the current registered medical marijuana patients to grow their own at home. It would remain prohibited, though, for recreational users in Pennsylvania. And again, you can see we got a real crazy mix here from state to state to state. They would establish a board to create regulations for cannabis businesses. And then this also would deal with expungement of past marijuana convictions and ensuring social equity for future cannabis-related businesses. This has been something that has popped up a lot, is the equity issue, where we have states, where counties, say in Maryland, that are majority African-American. And then when they gave out the initial licenses to run the cannabis businesses, none of them were given, or very few were given, to African-American businesses. And so Maryland ended up being taken to court over that, and they issued additional licenses. But this is something other states are being sensitive to as well. Pennsylvania does currently have medical cannabis provisions, and that, unlike Maryland, does include protections from discrimination in the workplace. There are some carve-outs, though, and the reason I wanted to post this is to show just how detailed some of these laws get. Pennsylvania is one of the most detailed. You cannot discriminate against an employee or an applicant for their status as being a medical cannabis patient. But if you have more than 10 nanograms in the blood, you can't operate or be in control of chemicals that need a license, or do work on high voltage electricity or public utility. Now I'm going to pause here, because this is an older law. And since this came out, and indeed since the time when a couple of states adopted blood THC levels as per se driving while impaired. Colorado and Washington State adopted 5 nanograms for that purpose. There was a big study on this, and there was a consortium of sheriffs that ended up issuing a report saying blood THC is not a good surrogate for impairment. It's apples and oranges. And so they have urged states not to use that in any of their driving while impaired laws. So Pennsylvania now is kind of stuck with this as a legacy, but somebody who has 10 nanograms of THC in their blood is probably not impaired. There may be another way of determining their level of impairment, but that isn't it. So at some point, they'll probably have to go back and change that law. Now, Pennsylvania law, while saying you can't discriminate against someone for being a cannabis patient, you also don't have to accommodate the use on your site or premises. How do you police that? How do you know if somebody is, eating a lifesaver or eating a cannabis lozenge? Hard to say. I guess honesty, letting your policy be known, and just trying. If you see a cannabis wrapper in the trash, then they're giving themselves away. But people are pretty good at hiding these things. Can you discipline someone for being under the influence of medical cannabis in the workplace? Yes. What is under the influence? Again, not clear. It's not 10 nanograms per THC in the blood, though. We do know that. You also are not required to violate federal law. So if you have a quarry in Pennsylvania, MSHA says you can't be under the influence there. Obviously, that would prevail. And indeed, in Pennsylvania, they specifically exempt people performing mining activities or working at heights. So that's a lot of construction, or working in confined spaces. That's a lot of construction, and it can be manufacturing as well. And, a few other, cargo, I guess, cargo holes in the ship breaking, et cetera, while under the influence of marijuana. You can prohibit people who are marijuana patients from performing any task that the employer considers to be life-threatening. That's pretty broad, right? OSHA, they consider a whole lot of things to be reasonably likely to result in death. And the prohibition will not be viewed as an adverse employment action, even if it costs the worker money. They say, well, you can't work at this position anymore, but we'll let you be a cashier. You can't work in our warehouse, but you can work the checkout, and maybe it's $5 less an hour. Tough noogies. Under Pennsylvania law, that's okay. The other thing, though, and this is a bill, the last bullet there, the Senate bill and the House bills have now passed in Pennsylvania within this month, removing the list of specific qualifying conditions. So now a doctor in Pennsylvania can recommend medical cannabis to any patient at their discretion. It's no longer limited to a list of, chronic pain or PTSD, anxiety, depression, insomnia, chronic pain, spasms, seizures. Those are typically, anorexia, after effects of chemotherapy. Those are usually the laundry list in the states where they enumerate the medical conditions. But Pennsylvania, that's going to be going away. And another big case in Pennsylvania is just earlier this year, finally, Pennsylvania held that the Workers' Comp Commission erred in refusing to reimburse a worker for cannabis used for a workplace injury. And this was a big case, Firestone Tire and Rubber. They had the money to litigate it, and they lost. The worker was injured during employment and had been using narcotics for work-related pain relief for 30 years of opiates. And his doctor recommended switching to medical cannabis, and it was effective. Wow, huge. But initially they said, well, the workers' comp will pay for opiates, but not for cannabis. Now, Pennsylvania has joined a fairly long list of states where you do have to reimburse workers, you, the employer, if you're self-insured, or your insurance company, for medical cannabis if it is used for the treatment of a workers' comp injury. And specifically in that decision with Firestone, the Pennsylvania court distinguished between coverage and reimbursement. So you're reimbursing for workers' comp, but you do not have to cover medical cannabis for treatment of non-work related injuries. That is kind of where the court split the baby on that one. And the Medical Marijuana Act in Pennsylvania prohibits patients from being denied any rights or privileges because of their lawful use. So that's really where things stand right now in Pennsylvania. What about Virginia? Very, very quickly here, because I do have a few other things I want to get to. When they legalized recreational cannabis, the 2021 bill does not offer employment protections for recreational users, but they added for the first time protections for medical cannabis patients in the state of Virginia. You cannot be discharged, disciplined, or discriminated against as of July 1st, 2021. So that's been in effect for 2 years now. If you have a positive test and you're a medical cannabis patient with a valid card, the employer cannot terminate or discipline you solely on the basis of that positive test. Now, if you violated safety rules, or you fell asleep on the job, or you had other things that were a code of conduct violation, you could terminate them for that. But you can't use the medical cannabis use as an enhancement or the sole basis for that. You don't have to change your drug testing policies in Virginia, so they say. Stay tuned on that for a second. Certain categories of jobs, healthcare especially, you can drug test regardless of any signs of impairment or certification. You don't have to violate any federal laws or contracts. And then they carved out for the defense industry that you don't have to allow someone to come to work for you or keep them or not discipline them if they're positive, but only if the test is above 50 nanograms, and that is a urine test we're talking about now, not a blood test. Well, many companies use 50 as the gold standard, no pun intended, but the problem is many companies use a lower cutoff, 25 nanograms, 30 nanograms, as a confirmatory cutoff. Most people are not actively impaired at 50 nanograms or less. That's the problem. Above 50, you're getting closer to current or recent use. But when you start getting down to 20 nanograms, you're capturing what they did over the weekend. You're not capturing what they did that morning. And the cannabis is stronger, admittedly, than it was back in the days when I was in college. But it still doesn't keep you stoned, for days. Usually 4 to 5 hours is pretty much the window there. And same thing for edibles. They may, depending on how much you eat, they might have a longer life, but most people, if they're using them medically, they're not abusing them and getting themselves into trouble with that. So the new law does provide a bone for employers, and it's a complete bar to recovery under workers' comp if the injury results from intoxication, and that's drugs or alcohol, but only if that impairment caused or contributed to the injury. So the stuff where there's a lagging indicator, but it's a low level, it's not going to get you a relief from this. Now, some other states, obviously still, if they can test any, then it's an absolute bar to recovery, and that has some pretty draconian results, unfortunately. A few federal, or not federal, but key decisions. As I mentioned, there's a lot of use now of the state laws in lieu of the federal ADA. The Knopfsinger case was interesting because it was in the federal court, but they brought it under the Connecticut medical marijuana law, I think because of diversity. And this is, again, something to watch. If you are working in Virginia and living in Maryland, and there's a discrimination action, you might be able to get that into federal court because of diversity. But they would still use the state medical cannabis law. So in this case, the applicant won because the state law did have worker protections. However, the court denied her claim for negligent infliction of emotional distress and her claim for attorney's fees. This also was in federal court because the employer argued federal preemption and said that because it's illegal federally, it would be illegal for the employer to employ somebody who is a cannabis user, a drug user. And the federal court rejected that and said, no, the Federal Controlled Substances Act does not regulate employment, and therefore it is not illegal to employ a marijuana user. or indeed any drug user for that matter. So that was the importance of that case. Coates, the Colorado case from now a number of years ago, was really the last big one where they tried to bring it under the federal ADA, and Michigan, they said, nope, there's no protections for employment. So all that does is protect you from being arrested. But of course, if the federal laws change, then that and many other case law decisions that held for the employer based on the federal ADA will go out the window. The Cassius versus Walmart case was one of the first big ones on that. This was also under Michigan's medical marijuana law. Mr. Cassius had cancer. He had worked there for 25 years. He was legally using marijuana for his nausea from the chemo. And the court said, again, so sad, too bad. And he lost his job and his medical insurance. That was, again, a pretty harsh result. But that was over 10 years ago. Well, fast forward, and Walmart, the prevailing employer in that case, they just lost a big case in Arizona because the Arizona law does have protections for employees. And they were just running their old playbook, I guess, didn't stay current on that. So that's really another takeaway for you all. If you haven't revisited your programs in a number of years, they may be based on the assumption that really the federal ADA doesn't allow it, and so you don't have to accommodate. Many states now have built these employment protections into their laws, either initially in some of the newer states or after the fact by going back and reopening the laws. And I expect, again, that Maryland is going to do the same to align them, say, with Pennsylvania and Virginia. Why would, if you're a medical cannabis user and you live in that area where the states all align, why would you come work in Maryland where you couldn't legally use your medication if you can use it in Virginia or in Pennsylvania and have some employment protections? So, that's the prism in which people are looking at these cases. Also note that the ACLU is on the playbook now, and they are bringing these cases, again, under the state medical cannabis laws, and they're developing a body of case law that is pretty impressive. Some of the states, we already mentioned Virginia and Pennsylvania, obviously, and New Jersey is another one where the states have cobbled it together from case law, but right in the statutes, Arizona, Connecticut, Delaware, Illinois, Maine, Minnesota, Nevada, and New York. They are all states that have protections in employment for their medical cannabis users. These are the states, very quickly here, that allow reimbursement for medical cannabis for workers' comp patients. Arizona, Connecticut, Hawaii, Maine, Minnesota, New Hampshire, New Jersey, New Mexico, New York, Pennsylvania, Rhode Island, and Vermont have all said, yes, you do have to reimburse it. Delaware and Maryland, there's been cases that have gone both ways, and only Florida, Massachusetts, Michigan, and North Dakota have said, no, you don't have to reimburse it. Real quick, if you're going to have a program and revisit your program, before you do any drug testing, make sure you have a written policy. Some states require that before you can do any testing. Make sure you do supervisor training on impairment recognition. These green labs that the Chesapeake's doing are a great start, and the education classes that go along with it. Employee education. What are the hazards of working while impaired? Raise the level of awareness that this isn't just, harmless. And if you're doing safety sensitive positions, you do need to be attuned to that, and coordinate and, communicate with the employer, especially if you're using it intermittently. There may be some flexibility that they would give you under the Maryland Human Rights Act, which is the analog to the Americans with Disabilities Act. Make sure you have an employee assistance program, because if somebody does want to get help for a drug or alcohol program, if they can address that before getting busted on a positive test, you can retain that human resource. That literally, our greatest human resources are the employees. But, also think about, if somebody tests positive for cannabis, sending them to drug treatment is not going to be necessarily the solution, especially if they are using it as an alternative to opiates. Because you're going to have them go to a 30-day treatment program to get off of medical cannabis so that they can go back on opiates for pain. That one makes your brain hurt a little bit. In your policy, make sure you have a rationale. Why are you even testing if you are testing? What's prohibited? Are you focusing on impairment, or is it a gotcha game with a positive test? What's your cutoff going to be? What are you testing for? Who's going to be tested? Is it everybody from the CEO down to the janitor, or is it certain bargaining units? What's the consequence of a policy violation? You know, what's the enforcement means? How are you testing? Is it urine? Is it blood? Is it sputum? Is it hair? Make sure you're aligning with your state testing requirements, because they all have unique things. Do you have an EAP? Make sure people are eligible for that. Try to cover drug and alcohol and mental health treatment as part of your employee benefits package. And if you are union, make sure that any changes to your programs are done in conjunction with your collective bargaining agreement and bargaining unit. If you unilaterally make changes, even if it benefits the workers, you may still end up on the wrong side of a National Labor Relations Act suit under Section 8A1 for changing terms and conditions of employment. Reasonable suspicion testing is allowed in all states, but there are some specific provisions in medical cannabis states that you're going to have to watch out for, as well as I've already mentioned, the municipal laws in some of the larger cities. And they may limit testing completely, including pre-hire testing, especially in non-safety sensitive positions. Now, DOT, they're a pure life form. In the interest of time, I've summarized the DOT distinctions between reasonable suspicion alcohol testing and reasonable suspicion drug testing. Make sure you follow those, but that's a subject for another webinar. And what is impairment? A lot of employers were doing the limbo rock. They were, how low can you go? And if you could accurately test down to 20 nanograms, then by God, that's going to be our limit. Well, the federal SAMHSA, which is the Substance Abuse and Mental Health Agency, they recommend 50 nanograms. If you're using a lower cutoff, you're going to be possibly capturing CBD only products. They are legal in all 50 states. They are not psychoactive, but they do potentially contain up to 0.3% THC legally. And there's been a number of cases now where people have been trapped up on that. There's also a growing trend toward getting away from a precise measurement number and using things like the Druid program, that captures functionality and cognitive changes against your own baseline. Sober Eye is another technology like that. The Hound breathalyzer, which is has completed some law enforcement testing, pilot tests, and now they've got a waiting list, I think, for industrial purchase. That purportedly captures cannabis that's used, vaped, eaten, or smoked within about a 3 to 5 hour window. And that's the sweet spot really for impairment. So that, I think, is a very promising technology. And, there's more coming to market. It's like Field of Dreams. If you build it, they will come. We've built all of these recreational and medical cannabis laws. Now the challenge is to discern truly what constitutes impairment. And relying on a random number is a little bit dangerous. Women have more fat cells. I'm not saying we're fatter, we just have more fat cells. THC is a metabolite that gets stored in the fat cells. So if I smoke a joint for the first time and Dave smokes the same joint, it's going to clear his system for testing purposes quicker than me, just on the basis of gender. Hair testing, people who have straightened or processed or colored hair, it's going to stay in there. It's going to pick up secondhand smoke. That's now being recognized even by the EEOC as having both gender and racial components to that test. So be careful in the testing methodology that you're using. Real quickly here, and I will stay on and answer questions. Illinois, we're not there, but they actually took the challenge on, and they defined impairment in their medical cannabis law, and it's in italics there. Well, it's really broad enough to drive a Mack truck through, symptoms of speech, physical dexterity and agility and coordination and demeanor. And half of that is me before I have caffeine in the morning, but they do go on where it's valuable, talking about disregard for the safety of themselves or others, carelessness in operating equipment or machinery, or involvement in an accident. And so that opens the door to post-accident drug testing, using that as at least an indicia of impairment. And so this is a paragraph I've been using when I've helped some clients redo their programs, because you're not arbitrarily writing it yourself. The state legislature at least considered expert testimony, and this is what they came up with. As I mentioned, CBD is legal in all 50 states. And what I want to hit on here is a lot of people, myself included, use that for pain relief. But if you don't buy it from a dispensary where it is sourced locally and tested, and you're buying it online, you're buying it, in a smoke shop, the University of Miami tested over 500 CBD products, including over 120 of which were intended to be taken orally. And they found 42% of them were positive for lead, 37% for mercury, 28% for arsenic. There was heavy metal contamination in those Delta 8 vape pens as well. And those do cause impairment, but they escape drug testing because it's relying on the Delta 8 metabolite rather than the Delta 9. And so with the CBD, there's been a couple of cases recently, including one last year with the operating engineers, and the worker did lose. He was using CBD. He argued he was using it for a disability. Still lost. That was federal court in Indiana. DOT and DOD both have put warnings out saying, watch out for CBD. Don't use it. It's not going to be an excuse to a positive test. And recently in West Virginia, and this was earlier this year, a minor lost their working papers because the court found that they did test positive, even though it was for CBD. It violated their state mining laws. So there's a lot going on there. In terms of doing the affirmative defense under the state or federal ADA using direct threat to safety, employers need to be aware that a good faith belief that a risk is significant is not enough. Not enough. You have to have an interactive process with the worker, and you have to consider the duration of the risk, the nature and severity of the potential harm, the likelihood of the harm, and the imminence of the harm. So you can't just say, reefer bad. I saw that movie, Reefer Madness, and I thought it was a documentary. No, you have to deal with the worker. You have to deal with their medical provider if they give you access, or their psychiatrist if they're taking it for anxiety or depression or PTSD. Beyond that, have written job descriptions and make sure you are accurately classifying things as safety sensitive. You can't say, well, safety is a value in our company, so every position here is safety sensitive. That will not pass the straight face test in court. And if you have problems accommodating cannabis use, document what you've considered as an accommodation, maybe working from home. Explain why that was not sufficient to mitigate the risk, and make sure that you're using objective criteria with a non-biased decision maker and relying on sound medical judgment, including whether the doctor believes the person can safely perform their assigned duties, just like you would in a return to work examination after somebody is injured and is coming back to work. Train your supervisors on recognizing impairment, on handling things confidentially, discreetly, sensitively. I had a case not too long ago where a supervisor went up to a worker, told him he had to go for drug testing because they suspected impairment. And they did it right in the workplace. And the guy picked up a nail gun from his bench and he shot himself in the head. He could have just as easily shot the supervisor, but the company didn't know that literally the job was the very last thing this guy had going on in his life. And when he knew he was going to lose his job, he committed suicide. Make sure to get people who are under the influence or perceived as being such into a safe and private area, and have a second person there as a witness before you take any action. Document what you're doing. And if you do think the person is impaired, make sure they get home safely. Don't just tell them, I think you're impaired, go drive yourself to get drug tested. I actually had that in a Maryland case, and clearly the employee won in that case, because how could you think they're under reasonable suspicion and tell them to go drive a company car to get drug tested? Cognitive disconnect there. So what should you do now? Check your current programs, check them against the OSHA policies, watch for additional changes in the law this year and next, federal and state. Maybe shift to a fitness for duty approach to things, which is really what Druid and Sober Eye and those types of things are. Watch for changes in Maryland and other state laws under state ADAs. this is the time to put this on the agenda if you're union, to add to negotiations the next time your contract is under review. Train those supervisors on recognizing impairment. And the bottom line is treat your workers fairly. Don't treat injured workers in a disparate manner. Don't use drug tests as a club to keep them from reporting injuries. And, if someone is a medical cannabis patient, they're still a valued human resource. See if there is a way that you can preserve that relationship in a way that can enable everybody to do their job safely and effectively. So thank you. I'm sorry I was a little long-winded here, but there was an awful lot to discuss. And Kim, I'll turn it back to you. It looks like we do have a lot of questions in queue, and I'll let me know how you'd like me to handle these, whether you want me to read them or if someone there wants to read them.
Debbie?
I'm sorry.
I think Debbie's
I'm
going
here.
to mention.
Thank you.
There we go.
I'm going on video, and Adele, I've pulled some of the questions for you, and we'll go through them, everybody. And if we get any more in, we'll make sure that we get them in the documents afterwards.
Oh, okay.
So the first question is, we are an employer based in Washington, D.C. Our employees live in Pennsylvania, Maryland, Virginia, and D.C. From the employment side, we only need to follow D.C. cannabis laws, correct?
Well, it depends. If your workplace is in DC, then yes, the DC laws would apply.
Thank you.
Now, if you are a construction company based in DC and you have mobile work sites, that's where it starts getting dicey, because one day they might be assigned to work in Virginia, one day they might be assigned to work in Maryland, one day they might be assigned to work in Pennsylvania. And then you're going to have these different laws that could potentially trigger. And we just don't have a huge body of case law where you do have these kind of diversity matters. And the one case that I gave you an example of there, the worker won because they were able to invoke the more protective state statute.
Understood. Can an employee be terminated for being arrested for possession while on the job?
Well, that depends. And I'm going to say, be careful on that. If they have driving duties and it involved, say, driving under the influence, you can certainly suspend them from driving while that matter is being resolved, especially if their license is no longer valid for a period of time. But you might need to look at reassigning them to a non-driving position, depending upon what your handbook says and if you're union and everything else. But where I'm going on the arrest thing, an arrest, everyone is innocent until proven guilty. And the EEOC has specific guidance saying that in general, employers should be wary completely of using arrests because of the racial profiling issue. Black and Hispanic men especially are much more likely to be arrested than their Caucasian and female counterparts, even if those arrests do not lead to a conviction. And so if you're taking employment action based solely on an arrest, it could be premature and you could end up getting sued on that basis. Now, in terms of convictions, the EEOC says you can consider a criminal record of an employee, but is it germane to the job? So the fact, and especially with drug cases, again, there's been a hugely disparate history of minority individuals being arrested for simple possession versus Caucasian counterparts. So I would advise against that. But if someone is arrested for cannabis use while driving, then you could limit their driving assignments for, on the job. That clearly would make sense.
Yes. Next question. Would documenting the individual's contribution to an accident protect a company from an employee going after them?
Well, that's I'm trying to process that question. An employee who is injured is going to go after the company for workers' comp because it's no fault. And saying that an individual employee's misconduct caused that, it's still usually an exclusive remedy. So normally a worker would not go after a coworker in tort if they had a worker comp remedy available to them. Now, with OSHA, if somebody was impaired and the employer did not know about it, that could be employee misconduct defense that could be raised, in that type of case. But usually an employee going after, and I'm using that in the phrase that it's used there, an employer for an injury, that's going to be under the no-fault workers' comp, regardless of whether a coworker was impaired or not. And that comes up in a lot of cases. I've never heard of a workers' comp case being denied because the person who caused the accident was impaired. If the person who's injured was found to be impaired, that is a basis in some states for denying workers' comp, but not if if the separate employee caused the accident and was impaired.
Thank you. Can I conduct an instant test in conjunction with a lab-based test to return someone to work following an incident?
Yeah, and in fact, companies do that. They might use the mouth swab initially. If it's negative, sometimes they don't bother doing any follow-up lab test. If it's positive, you do not use the mouth swab as a legal drug test, though. That would be, the trigger then to send them, for urine testing or whatever other testing you're doing.
Do you see any legality issues with impairment testing versus drug testing, as impairment may be more subjective?
Well, I'm going to be very careful in how I answer this. The impairment approaches, Druid and Sober Eye, I'll use those two, and there may be other ones out there. Those are the two I'm most familiar with. They themselves are very clear. This is not a drug test. And I agree with them. It is an assessment of fitness for duty from all causes. And one of the things I like about that approach, and I'm frankly advocating that, as opposed to a numerical approach, is that it'll catch things like fatigue and stress, and maybe illness that might have the person not at the top of their game, for that reason. We get very myopically focused on cannabis use, and we tend to disregard the fact that if somebody's coming in on 2 hours of sleep, they're more dangerous than if they had had a couple of beers before they came to work. And that is something that's pretty well documented. And I think, in the wake of COVID, we have people who have a lot of sleep disruptions now. We have people who have brain fog that is totally unrelated to any drug or alcohol use. And so changes in that individual, including from long COVID, are going to be picked up against their original non-ill baseline by these Druid and Sober Eye systems, and those kind of deficiencies, the stress, the insomnia, the illness, those aren't going to be captured by a drug test. So in terms of legality, though, I would not fire somebody on the basis of a Druid test. I might refer them for a drug test based upon their performance on a Druid assessment, but the Druid or Sober Eye assessments themselves are not drug testing, and so would not be regulated under Maryland or other state drug testing laws at present. That landscape could change too.
Thank you. So we are going to wrap this up. Thank you, Adele, and my fellow employees at Chesapeake Region Safety Council. We mentioned a couple of times, and Adele did as well, that we have an impairment education and cannabis use workshop. You can find that in the link that was just posted in the chat. And along with that, for those of you that are very interested in the safety sensitive positions, we offer the same day concurrent reasonable suspicion class. And you can find that as well in that same link. There's a link for our upcoming annual safety and health conference on October 4th and 5th. And Adele will once again, as always, be there and sharing some of the same information and any updates that are relevant. And please reach out to us with any subsequent questions. You can email safety@chesapeakesc.org. And thank you very much. Dave?
Yes, thank you, Adele. Adele, as always, just a wealth of knowledge. And I greatly appreciate everything you had to talk about. I can't emphasize enough to people who are on this call, if you want to learn more, to try to attend one of our impairment workshops. You're going to learn a lot more. You get an opportunity to talk to some of the cannabis users, law enforcement, and really get a good grip at understanding what impairment really is. So I just want to say thank you very much to everybody that attended, and thank you very much to Adele Abrams for all of your insight. And we look forward to seeing each and every one of you come to the council for some of our training programs. Thank you. Have a great day.